Today we speak with Christopher Black, who's an attorney that's practiced before the International Criminal Court, about the case currently before the International Court of Justice, which is a different court altogether, involving South Africa and Israel over the question of genocide. He's based in Canada, across Lake Ontario from Rochester. Chris, thank you for your time, first of all, and give us an understanding of what the actual court is and how it works.
The ICJ is a legitimate court established at the same time as the United Nations in 1946. It's an integral part of the United Nations and therefore has legitimacy. It's a court set up to settle disputes between nation states about interpretation of treaties and international law, state boundaries and things like that. And it's composed of a body of 13 judges selected from different countries around the world. But in each case, the parties can ask to have an ad hoc judge appointed as well, which I find absurd anyway. And it has no enforcement mechanism. Whatever its decision is, there's no method to enforce their decisions except by application to the Security Council to get their assistance to force a nation to abide by its decision. But otherwise, its decisions are declaratory or advisory in a way.
So there's not going to be, for example, a criminal conviction of any individual, Netanyahu, the head of Hamas or whatever, that comes out of this. There's no jurisdiction for that. It's not part of this court's function. And there's not going to be a criminal case against Israel or anyone else either, correct?
That's correct. Only the ICC, the International Criminal Court, can do that, and they have an open file on the Israeli-Gaza issue since 2014. Have done nothing, and I expect them to continue to do nothing.
And then if the court finds for South Africa that, in fact, Gaza, the situation in Gaza, Israel has been committing genocide, that's the end of it. They have no right to enforce it, and no one else has.
It'll be a declaratory decision, and Netanyahu has already said whatever the decision is doesn't matter to us. We're going to keep on doing what we intend to do.
So the Genocide Treaty itself places an affirmative obligation on the signers, if they see genocide, to put a stop to it. The UN Charter does not allow military action except for close-up self-defense or an approval of the Security Council. So if there's a judgment from the court that this is genocide and it's clear that that's what it is to everybody else, and there's a resolution brought to put a stop to it at the Security Council, and the US or UK or France or somebody vetoes it, that's the end of it legally, correct?
Correct, legally, yes, it is. So it would have a propaganda value or a political value to be used by various states and people to argue the morality of what Israel is doing, but it would have no further legal effect now.
Okay, very good. Okay, so if you would explain to lay people like myself what exactly we're looking at when we look at the case.
Well, let's put it this way: the South African application was very well made, but the South Africans have to establish two things to succeed in this hearing, and that is A, convince the court they have standing to make the claims against Israel, and secondly, that the claims that they provide amount to genocide, or can be interpreted as possibly being genocide for provisional measures. And so they made a very good argument, and I think they made a compelling argument that they do have standing. And what that means is that under the Genocide Convention or under the ICJ statute, two nation states have to have a dispute between them before one nation can apply to the court for its assistance. So in this case, South Africa says, we have a dispute with Israel about the interpretation of the statute of the Genocide Convention. Israel's defense was, there is no dispute between us and South Africa about the Genocide Convention. We have not been notified of any such dispute. We're not aware of any such dispute. They have no standing to make such a claim against us because there is no actual dispute between us, two nations. South Africa, I think, made a compelling argument. How the court goes, we don't know, but they made a compelling argument that they did make Israel aware of South Africa's objections to their actions in Gaza, that they were genocide. They said it multiple times It was in the press. It was common knowledge around the world. Israel could not have been ignorant of it. And they sent a note verbal to the Israeli embassy in South Africa, the government, stating that they were in violation of the convention. They must stop what they're doing. Israel did not respond to that, but they have to be seen as accepting that document and being aware of the dispute. So I think they have a good argument, but Israel is trying to say, no, there is none. So if South Africa crosses that threshold, then we get to the actual case of the merits, whether they provided enough information to convince the court there's probably acts of genocide being undertaken by Israel. I think they made a very good argument for that way.
I just want to get some clarity on a point. In essence, this court is for disputes between nation states, and
Right.
Israel is saying, hey, South Africa, you're bringing this case against us. We don't have a beef with you. And that's essentially their defense there?
Basically, yeah. They're saying, we don't have a beef with you. We don't know what you're talking about.
Okay, so go ahead. I'm sorry. I didn't mean to interrupt. I just wanted to get...
That's okay. Yeah, so that's it. And then we get into the merits of the claim. So assuming that the court finds South Africa does have standing and there is a dispute, then what's the dispute about? It's about Israelis' actions in Gaza against the Gazans, the Palestinians there. And they provided ample evidence of military actions and statements by public officials, public statements by Israeli officials, and they have many of them, which made a very compelling case that Israel is engaged in actions which can be interpreted as an attempt to commit genocide against the Palestinian people under the Genocide Convention. The Israelis responded by saying, at the opening of their defense, made the astounding claim, which is false and a lie. Mr. Shaw, the British barrister that said this, I was surprised that he actually said this. It was shocking, really, because he claimed that on October 7th, Hamas attacked the sovereign territory of Israel, which is a lie, because we all know and the world knows, and the United Nations and the ICJ itself has said that and the ICC as well, that those lands are occupied territories, occupied illegally by Israel in an act of aggression in 1967 and following after that. And therefore, Hamas had every right to attack those occupation forces as resistance forces can do. And therefore, as a consequence, because they're occupation forces do not have any right of self-defense whatsoever. Their only response to an attack by resistance forces is to withdraw. That's the only legal thing they can do. But Israel argued that they attacked sovereign territory of Israel in order to avoid that argument, and then to claim that they acted in self-defense. And then it becomes a matter of proportionality, whether they acted with more force than was necessary for the task or reasonable force. And that's where the argument comes in. And in their defense about the merits, they just denied it. They just said, we're using all proportional force, we're doing what's necessary to counter the threat from terrorists, and so on and so forth. There was no real meritorious defense. It was just a lot of rhetoric.
You know, the case that was presented by South Africa, one of the attorneys anyway, she detailed how many bombs and what types of bombs and things were being dropped and all of that. You know, all these factual claims that practically themselves, you know, lay out a case for genocide.
Right.
We dropped like one bomb for every human being kind of factual claims. Did Israel contest any of the facts, like specifically say, no, that's not?
No, they didn't. They just basically said that they didn't address the particular item by item claim of this day they dropped this many tons of bombs and they attacked indiscriminately and they made public statements, different cabinet ministers of Israel saying we're going to wipe them out and we're going to kill them all. There was no response to the details of those claims. They just generally gave a ballpark or just a vague statement. We didn't do it. We're not doing anything wrong. We're only doing what's necessary to fend off an attack. You can't accuse us of committing genocide when our people we're almost wiped out in the genocide by the Germans in World War II, and we're the victims, and we're still the victims of these further modern terrorists, and therefore you can't look at it the same way, and blah, blah, blah. They didn't even try to address the claims, because that would have taken a long time, and they didn't want to admit that they're really occurring like that. We're just doing what we think is necessary, is proportional, and we obey the rules of war. Our forces are told to obey the rules of war, and so on and so forth.
Yeah, I mean, if they've made specific denials, then presumably there'd be some trial of that, right, where the evidence is presented for and against publicly. And
well, that would come later, because this motion was just for provisional measures. The actual discussion about the main case would take place later. This is just a preliminary. It'd be like at a bail hearing. You're charging somebody with a crime, but there's a pre-hearing to determine whether the person charged should be held or released. And in this case, we got this claim that they're committing genocide, but until the main hearing takes place, we want some measures taken right now to stop them continuing their crime.
Wow, okay.
That's what's happening now. The danger is with the South African argument is they made some I think errors, and I wouldn't have argued the way they did. They opened with a statement condemning Hamas's attack and stating that they committed some crimes, which is factually doubtful and is in dispute. And some of the things that they spoke about have been proven to be false and just Israeli propaganda. And I think that undermined their case, because then Israel says, you see, South Africa agrees with us that Hamas committed crimes when they attacked on October 7th. Therefore, we have a right to respond. And they were terrible crimes. South Africa should have just stated, in my view, that on October 7th, the Palestinian resistance forces under Hamas and other groups in Gaza and conducted a military operation against occupation forces, a legitimate resistance. And what happened in that can be disputed, but that was a legitimate attack. And the Israelis have no right of self-defense. They can't argue self-defense because they have no right to self-defense in this situation, but they didn't argue that. And then they go on, after that, they went into a long recitation of all the actions of Israel and the statements which indicate they're committing genocide. And I think that was very well done. But then when they get to the Irish lawyer,
Blenheim Harley,
disappointment made me angry a bit, because she said the international community has let these things go before in Rwanda and Bosnia. Well, if she had said things correctly, she would have said the international community has in the past approved these genocides like Rwanda, because Rwanda was conducted by the British, Americans, Canadians, and Belgians. And Bosnia was part of the Yugoslav wars, which the Americans and Germans and British instigated. And she could have, instead of mentioning those two examples, she could have said, Israel is conducting the same sort of massacres against people as the Americans conducted against Iraq and Afghanistan and Libya, in which nobody did anything about. But she didn't mention all those.
Yeah.
And that angered me. It seems to me they wanted to please two parties at the same time. They wanted to please the world, the global South, perhaps by condemning Israel, but on the other hand, please the West by saying these other things. And you can't play a game like that.
Yeah, especially like this when you're talking about genocide. Chris, we're out of time, and I really appreciate your time, and thank you very much.
You're welcome.
For KPFK, I'm Don DeBar.